is Eyewitness News, now at 4.
If you haven't checked the calendar today, maybe you forgot, maybe things are looking a little hazy. It's April 20th, also known as 420. That's a holiday for weed smokers and cannabis enthusiasts. The origins of the celebration have been debated for decades, just like the legality of marijuana itself. As of today, recreational marijuana is legal in 21 states, including, of course, California.
Well, there are a number of laws on the books in California when it comes to marijuana, including one meant to stop employers from punishing workers who use cannabis when they're not on the job.
But how does it work, and what are your rights? Joining us now to explain is employment attorney Angela Reddock-Wright. Ms. Wright, thank you very much for joining us. Back in September, Governor Newsom signed that measure into law. It doesn't take effect until 2034. Can you explain what Assembly Bill 2188 actually does?
Well, thank you for having me on. Assembly Bill 2188, it basically prohibits employers from discriminating against employees for their off-duty use of marijuana, whether it be for medicinal reasons or recreational reasons. And it also precludes and prevents employers from firing or terminating or disciplining anyone if in a drug test that they find that that employee has what we call non-psychoactive traces of marijuana or THC in their blood system or in their urine system.
All right, well, and you meant to say 24. We said 24, but, you know, a couple years, 1 year from now. So yes. Are California employers still allowed to test for marijuana, drug test for marijuana, and can an employee be fired for failing a drug test that comes back positive for THC?
Yes, California employers can still do what we call pre-testing for marijuana and for other drugs. However, if in that pre-test it comes back with what we call non-psychoactive traces of THC or other substances, that's not enough to not hire someone. You have to find psychoactive traces or traces that actually cause an impairment to the person's ability to do the job. So we can have pre-employment testing, and during employment, we can have drug testing if the employer feels that the employee is somehow impaired in doing their job, possibly because of marijuana or other drug use. But even in doing that during employment testing, just merely finding traces of THC in the system is not enough to take action. It has to be at a level in which it is actually impairing the employee's ability to do his or her job.
And are the rules any different for medical marijuana versus recreational use?
It's not, because both medical and recreational use is now protected in the workplace. So really the rules are, it boils down to whether an employee is actually impaired in doing their job as a result of marijuana or other drug use. What employers can do, they can still prevent having or possessing marijuana in the workplace or other drug substances in the workplace. They can prohibit using it while you're at work, and they can still declare that they would like a drug-free work environment, but they can't control what you're doing outside of work unless it comes into work and causes some impairment or ability to do your job. And when it comes to medical marijuana use, there's a possibility in that instance that an individual's rights under the Americans with Disabilities Act would kick in, where if an employer tried to take action for someone engaged in medicinal use by saying that the employer is violating their rights under the ADA, that they have a medical condition or a disability which requires this, and then of course that requires a whole nother process under the law.
Okay, Angela Reddock-Wright, we really appreciate your time, and thank you for clearing the haze when it comes to all these marijuana laws. Hard to keep them straight. Have a good afternoon.
Happy to do so.
This interview should have taken place about 5 minutes from now. All right.
So true.
Thank you very much for joining us.